Welcome back to another video. We have a really huge development with the Microsoft Activision merger case. This is the CMA website and it's just been updated today with the summary of final decision on possible material change of circumstances / special reasons. It's a PDF. So we're going to have a read through this final decision on change of circumstances / special reasons. I've been checking the website every single day for an update and it's finally been updated today. So let's have a read through. Microsoft Activision Blizzard merger inquiry. And remember, I actually sent an email to the CMA because they asked for feedback on the Microsoft submission. They gave this notice inviting comments. So I actually sent them an email and I said, look, this Microsoft submission, it does not constitute a material change of circumstances because it's not actually taking into account the concerns of the CMA regarding the cloud gaming providers. So that's what I basically said in the email. It's not addressing the competition concerns because Microsoft's submission has so many flaws in the reasoning and argumentation. And I'll show you the email I sent to them a bit later. But that was my feeling back then. So I sent that email to them expressing my concerns and I said it does not constitute material change of circumstance. So the decision to prohibit the merger should not be changed or modified on that basis. It should go ahead and the deal should be blocked, in my opinion. So I haven't actually read the final order yet. I don't know what their final order is. I've only read just a little bit of this summary. But I'm going to read all of it now today. So this is also my first time reading it and my reaction, my real initial reaction that you will be seeing. So let's see what happens and what they say. So Microsoft Activision Blizzard merger inquiry. Summary of final decision on possible material change of circumstances or special reason for deciding differently under section 41(3) of the Enterprise Act 2002. 22nd August 2023, which is today. Number 1. This is the decision of the Competition and Markets Authority CMA on whether there has been a material change of circumstances MCC or a special reason SR under section 41(3) of the Enterprise Act 2002, the Act, for deciding differently on the remedy set out in the final report, anticipated acquisition by Microsoft of Activision Blizzard Incorporated final report, the report in the anticipated acquisition by Microsoft Corporation, Microsoft of Activision Blizzard Incorporate Activision, the merger. The full reasons of the CMA for this decision will be published in due course. Number 2. Following the conclusion of an investigation into the merger by a group of CMA panel members, the Inquiry Group, the CMA published the report on 26th April 2023. In the report, we decided that the merger may be expected to result in a substantial lessening of competition SLC in the supply of cloud gaming services in the UK due to vertical effects resulting from input foreclosure, and that the prohibition of the merger would be the only effective and proportionate remedy to the SLC. On May 19, 2023, we published a proposed order that would put in place measures to implement the decision of the report to prohibit the merger and invited comments on that proposed order. In response, Microsoft made a series of submissions culminating in a final and consolidated submission on 25th July 2023. Microsoft submitted that there had been 4 main developments since the report which individually or collectively amounted to an MCC or special reason under section 41(3) of the Act, and that as a result of these MCC/SR special reasons, the CMA should not adopt an order prohibiting the merger. Under section 41(3), the remedial action taken by the CMA, for example, through a final order, must be consistent with its final report, unless there has been an MCC or special reason since the preparation of the final report. The developments outlined by Microsoft are: number 1, the acceptance by the European Commission, the Commission of Commitments, from Microsoft, which Microsoft submits, provide a statutory underpinning and enforcement structure to the cloud gaming licensing agreements Microsoft entered into with NVIDIA, Boosteroid and Ubitus, the cloud agreements. Number 2, an agreement entered into between Sony and Microsoft providing access to Call of Duty, COD, the Sony agreement. 3, new evidence that has become available through litigation in the US relating to the merger. And 4. New information obtained by Microsoft through UK court proceedings relating to its appeal of the report. Point 5. We have received a number of submissions from the public and interested parties in response to our notice inviting comments on Microsoft's MCC material change of circumstance / SR special reason submission and have taken these into account as relevant. 6. Having considered Microsoft's submission and other submissions we received, we have found that none of the developments highlighted by Microsoft, either individually or cumulatively, constitute an MCC or SR under Section 41(3) of the Act that would result in a change to the remedy decision. So this is huge. This is exactly what I suggested in my email to the CMA. I've always believed their submission was basically the arguments they put forward were not good. They were flawed arguments. They were very easy to refute. And I did refute a lot of the arguments that Microsoft submitted. I didn't go through all of the report, but I did address some of the main points that they put forward with my concerns and my refutation. And the CMA seems to have agreed as well. They found none of the developments highlighted by Microsoft constitute an MCC, so they disagree with Microsoft about this changing their decision. 7. Before summarizing our assessment of Microsoft's claimed MCCs and SRs, we first make some preliminary observations. Following the conclusion of the detailed and thorough Phase 2 investigation, the CMA has a relatively short period of time in which to implement the remedy decision set out in the final report. It is well established in case law that it is not appropriate for merger parties to use this implementation period to seek to re-argue the merits of the CMA's case or to submit new remedy proposals, and it is rare for the CMA to receive submissions on MCCs or SRs in practice. 9. With particular regard to Microsoft's submission, some of the evidence or developments Microsoft points to as constituting an MCC or SR were substantially known and taken into account by the CMA at the time of the report. Other aspects of Microsoft's submissions do relate to developments since the time of the report, but we have found that they impact only a subset of providers or some limited parts of our substantive assessment. Our SLC finding was in the market for cloud gaming services in the UK and was based on a finding of Microsoft's ability and incentive to foreclose rivals in that market in general. Given that cloud gaming is a nascent, dynamic, and rapidly growing market, we do not consider that developments concerning a limited number of current rivals address the fundamental concern about the risk of foreclosure of other current and future rivals in the market, more generally, including those with innovative and new business models. This is exactly what I put to the CMA in my email as well. I pretty much said this about, what if Stadia comes out with their cloud gaming service, if they revive Stadia or some kind of YouTube playables, the new thing they're doing, and they have a new business model, and it's like the way that Stadia had their business model, then it doesn't align with Microsoft's licensing, how they are licensing the games, and their business models will be different, so that would be a problem. And that would affect competition, that would hinder competition. Anyway, continuing on. 10. Moreover, we assessed in detail in the report a remedy proposed by Microsoft, the Microsoft Cloud remedy that was substantially the same as the Commission commitments, and also shared many similarities with the cloud agreements. Having already reached our own conclusion based on the evidence before us, we consider that the subsequent adoption of substantially the same. Let me just read through this. Moreover, we assessed in detail in the report a remedy proposed by Microsoft, the Microsoft Cloud remedy that was substantially the same as the Commission commitments, and this is talking about the EU Commission commitments that made the EU finally accept and allow the deal to go forward in the EU, and also shared many similarities with the cloud agreements. Okay, I don't remember what the cloud agreements were about. I think that would have been the NVIDIA Boosteroid Ubitus agreements. I think this is what they're talking about here. And then the Microsoft Cloud Remedy was more overarching, like every cloud provider. It wasn't limited to those three. It was basically the remedy that going forward would come into effect for any cloud gaming providers. It's a bit confusing because there's so many different agreements and they're all basically the same thing but put in different terms. It's basically Microsoft's way of trying to evade the decision that was made by putting forward all of these different agreements. And I don't know if they believed that would change the decision, but it doesn't seem like the CMA is buying that. So let's read again. Reading ahead. Having already reached our own conclusion based on the evidence before us, we consider that the subsequent adoption of substantially the same remedy shortly after the CMA's decision by one or more overseas competition authorities is unlikely to have a material impact on the CMA's decisions in the final report. And this is why it's funny to me that Microsoft thought that this was a good argument. They were basically saying, look, this other regulatory body in the EU has approved it, so why don't you approve it? Well, the CMA's answer was that it's a different regulatory body. The EU and the UK, they are separate. They came to their own decision and their own decisions as a result of their own research, and CMA was basing it on the UK concerns for competition. And the Microsoft's argument was basically this provides more of a backbone, more substantial backbone to the deal not being altered and not allowing Microsoft to come out of the deal early, thanks to the EU also pressuring them. But then the EU would have all of the same problems in enforcing the deal that the CMA themselves highlighted, like the problems with enforcement of the remedy and not being privy to a lot of the details of the goings on inside of Microsoft. And they would basically have to monitor. They would need a monitoring trustee, someone to basically monitor the situation for the next 10 years. And that's a lot of work, and it's also very difficult to monitor effectively because of the complexity of the agreements. So any loopholes could potentially be exploited by Microsoft. So yeah, there was that. Unlikely to have a material impact on CMA's decisions in the final report, which makes sense. The CMA has their own decisions. They are separate from the EU. Just because the EU approves it doesn't mean the CMA has to approve it. Like, a lot of people are thinking that, but that's just silly. Like, just because one regulatory body approves it doesn't mean the CMA has to as well. And it's true, most of the world approved this deal, but the CMA looked at the evidence and they came to their own conclusion, and the evidence supports them, I believe. I don't know about these other countries and how far they went into investigating the actual evidence regarding cloud. But I know that the CMA went into a lot of detail in investigation in their final report. It's a 400-page report, and they really investigated things. So I have faith in the CMA that they did their due diligence. I don't know about the other countries. I don't know how well the EU actually investigated the matter, because they didn't release any final report. They didn't have any final report. They released a press report that was like 1 page or 2 pages, but they didn't have any assessment that I could go through and see, here is their reasoning for why they approved the deal, despite the evidence being against Microsoft actually, not having the incentive to foreclose rivals and the ability to foreclose rivals. In addition, where merging parties take action in the intervening period between the final report and final determination of the reference to seek to address some but not all competition concerns in the final report, for example by entering into new supply agreements with third parties that still preserve the ability and incentive to foreclose more generally. We consider that these are also unlikely to have a material impact on the CMA's decisions in the final report. So when they say new supply agreements, I'm guessing that's the thing with Nware, and Nware unfortunately has just closed down. I don't know what other new supply agreements there would have been. Let me think back. Maybe they made some kind of agreement with EE, I think it was, in the UK, which is a telephone company, mobile telephone company in the UK. So yeah, because that would be behavioral change maybe, but it would not be a structural change, right? Because the CMA wanted to see structural changes, but they cannot approve the deal on behavioral changes alone after they've issued the final report that has blocked it. In this case, we have considered the developments submitted by Microsoft carefully and in detail. In relation to the cloud agreements and the Sony agreement, we find that while these developments have some limited effect on parts of the analysis and reasoning in the report both individually and cumulatively, they ultimately do not significantly impact the reasoning in the report and do not constitute MCCs/SRs for the purposes of section 41(3) in the act that would result in a change to the remedy decision. In relation to Microsoft's submissions on the information and evidence arising from court proceedings related to the merger in the US and the UK, we find that this has little to no impact on any of the reasoning or conclusions set out in the report and does not constitute MCC's SRs for the purposes of section 41(3) of the Act that would result in a change to the remedy decision. We find that considering all of the developments submitted by Microsoft cumulatively does not change the assessment. As we have found no MCC or SR under section 41(3) of the Act, we will now take remedial action that is consistent with the remedies decision in the report. i.e. action to effect prohibition of the merger. We will therefore proceed to implement a final order to effect the prohibition of the merger. So this is absolutely huge. I'm kind of struggling to believe these words, that we've been waiting so many months to finally get this decision, and it's like the end of a huge chapter, like a end of an anime, kind of the final episode of the anime. This battle between the CMA and Microsoft, and the CMA kind of finally saying, no, we won't accept this. We don't accept your terrible arguments. We say no. And I say, good on the CMA, respect to the CMA. But we haven't read the final order yet, so we don't know what they're going to say. Maybe they accept or maybe they refuse. So far, it looks like they're going to effect prohibition of the merger, as they put it. So we're going to look at the final report now, the final order. So 22nd of August, the CMA gives notice of the making of the Microsoft and Activision Merger Inquiry Order 2023. On the making of this order, the reference is finally determined. So first of all, notice of making the order. The Microsoft and Activision Merger Inquiry Order 2023. Notice of making a final order pursuant to Section 84 of and Schedule 10 to the Enterprise Act 2002. Introduction. On 15th September 2022, the Competition and Markets Authority, CMA, in exercise of its duties under Section 33 of the Enterprise Act 2002, the Act referred the anticipated acquisition by Microsoft Corporation, Microsoft of Activision Blizzard Incorporated Activision the merger for further investigation and report by a group of CMA panel members. 2. The CMA published anticipated acquisition by Microsoft of Activision Blizzard Incorporated final report, the report on 26 April 2023. In the report, the CMA decided, in accordance with Section 36 of the Act, that the anticipated acquisition of Activision by Microsoft constitutes arrangements in progress or in contemplation, which, if carried into effect, will result in the creation of a relevant merger situation. The creation of that situation may be expected to result in a substantial lessening of competition in the supply of cloud gaming services in the UK due to vertical effects resulting from input foreclosure. The CMA should take action for the purpose of remedying, mitigating, or preventing the SLC or any adverse effect which has resulted from or may be expected to result from the SLC, and the prohibition of the merger would be the only effective and proportionate remedy to the SLC and any adverse effects which have resulted from or may be expected to result from the SLC. Pursuant to Section 41(3) of the Act, the remedial action taken by the CMA must be consistent with the report, unless there has been a material change of circumstances since the preparation of the report, or the CMA otherwise has a special reason for deciding differently. On 19th May 2023, in accordance with paragraph 2(1)(a) of Schedule 10 to the Act, the CMA gave notice of the proposed order to remedy, mitigate, or prevent the SLC and any resulting adverse effect which it identified in the report. The notice and the proposed order were published on the CMA website. The CMA invited written representations on the proposed order from any interested person or persons with a deadline of 19th June 2023. In response to that notice, Microsoft made submissions to the CMA about developments since the publication of the report. These submissions stated that there had been a material change of circumstances since the report, or that there were otherwise special reasons for reaching a different decision on the remedies question. Microsoft provided its final and consolidated submission on these matters on 25th July 2023. A non-confidential version of Microsoft's 25th July 2023 submission was published on the CMA's website on 31st July 2023. On the same date, the CMA published a notice inviting comments on Microsoft's submission with a deadline of 4th August 2023. The CMA received responses from interested parties in relation to Microsoft's submission, which it has carefully considered. The inquiry group has decided, under Section 41(3) of the Act, that there has been no material change of circumstances since the preparation of the report, and that the CMA has no special reasons for deciding differently. As a result, the CMA's decision under Section 41(2) of the Act must be consistent with the decisions included in the report. The full reasons for the inquiry group's decision regarding material change of circumstances or special reasons under Section 41(3) of the Act will be separately published on the CMA's case page in due course. The CMA also received submissions from Microsoft and one other interested person in response to its initial consultation of the proposed order. Microsoft submitted that the terms of the proposed order were disproportionate in relation to the SLC identified due to its duration, and that it extends to all subsidiaries of Microsoft and Activision. On the question of duration, the report explained that the competition concerns identified were not time limited, and that the inquiry group found no compelling reason to depart from the merger remedies guidance in this case by seeking a shorter or indeed longer prohibition period. Excluding particular subsidiaries could create a circumvention risk, and the order in any event enables prior written consent of the CMA to be sought. See paragraphs 12 and 13 of the order, which the inquiry group does not consider would create an unnecessary regulatory burden on the parties in the circumstances. Further, we found in the report that a number of composition and purchaser risks would be associated with a partial divestiture, and substantial additional evidence would be required from the parties to enable us to assess whether it would be an effective remedy. The parties did not provide any such evidence. And there is no basis for reconsidering this issue at this stage of the process. The inquiry group is satisfied that the proposed order is consistent with its decision on remedies as set out in the report, and that the terms of the proposed order are necessary. To implement an effective prohibition of the merger. The inquiry group does not, therefore, consider it necessary or appropriate to change any of the terms of the proposed order. Another interested person, an academic, submitted that the CMA should reverse the decisions in the report for a variety of reasons. This submission sought to re-argue points that were decided in the report. The inquiry group considers these to be criticisms of the report as it stands, which are not based on changes or developments that have taken place since the report was published, nor are they specific to the appropriateness of the proposed order more generally. As such, the inquiry group did not consider this submission relevant to this stage of its inquiry. The CMA now gives notice of the making of its final order, the Microsoft and Activision Merger Inquiry Final Order 2023. The final order comes into force on 22nd August 2023. The final order may be varied or revoked by the CMA under sections 84, 3 or 162 of the Act. This notice and the final order have today been published on the CMA's case page along with an explanatory note. On the making of the final order on 22nd August 2023, the reference is finally determined as at that date pursuant to section 79(1)(e) and 79(2)(e) of the Act. Martin Coleman, Group Chair, 22nd August 2023. So there we have it, ladies and gents. That is the final report. The CMA has just said no to the deal going forward. No Microsoft Activision deal going forward in the UK. They have basically put forward the hammer, struck the hammer, so to speak, and the decision is sealed and official. Finally, after all these months, we've been waiting for this decision, and I've been arguing in favor of the CMA and the final report, the decision. So I'm satisfied that they have done their due diligence and they have done what was necessary of them. I'm happy, and I also emailed them with my own concerns about the final report, about the Microsoft submission and why I believed the submission did not address anything really. It was just there to re-argue old points, like the CMA said. And let's have a look at the order. The Microsoft and Activision Merger Inquiry Order 2023. So now that we know that this is the final order, the question is, what will Microsoft do now? Will they come out of the UK as a market entirely to pursue the deal? Because that's what they're going to need to do. Or will they divest part of the company? But then the CMA has said there is risks associated with doing that. That if they divest, it won't necessarily mean that the CMA still accepts the deal going forward. So it's very interesting to see what will happen now. What will Microsoft's next move be? It's like a chessboard, kind of looking at the chessboard. The pieces are being moved, and the CMA has made their move, kind of a checkmate move, if you ask me. And Microsoft has no option now other than potentially to exit the UK or simply drop the deal entirely. So this is very interesting. My personal interest in all of this is obviously the cloud gaming side. I'm a massive fan of cloud gaming, and I believe in the future of cloud gaming. I want Activision Blizzard games to come to all cloud gaming services, not just Boosteroid, but all of them, including GFN, Amazon Luna, Sony's PS Plus Premium, and Xbox Cloud Gaming. All of them. I want all of the cloud gaming providers to benefit and to thrive. I don't want one singular one to come out on top and prevent competition from happening naturally. Anyway, let's have a read through the CMA's final order. So this is basically the end point of the anime, the final episode, the thing you've all been waiting for. Let's have a read through it. The Microsoft and Activision Merger Inquiry Order 2023. Background. On 15th September 2022, the Competition and Markets Authority CMA, in exercise of its duty under Section 33(1) of the Enterprise Act 2002, the Act, referred the anticipated acquisition by Microsoft Corporation, Microsoft, of Activision Blizzard Incorporated Activision and the merger for further investigation and report by a group of CMA panel members. The CMA published anticipated acquisition by Microsoft of Activision Blizzard Incorporated final report, the report on 26 April 2023. In the report, the CMA decided, in accordance with Section 36 of the Act, that A. The anticipated acquisition of Activision by Microsoft constitutes arrangements in progress or in contemplation which, if carried into effect, will result in the creation of a relevant merger situation. B. The creation of that situation may be expected to result in a substantial lessening of competition (SLC) in the supply of cloud gaming services in the UK due to vertical effects resulting from input foreclosure. C. The CMA should take action for the purpose of remedying, mitigating, or preventing the SLC or any adverse effect which has resulted from or may be expected to result from the SLC, and D. The prohibition of the merger would be the only effective and proportionate remedy to the SLC and any adverse effects which have resulted from or may be expected to result from the SLC. 3. On 5th May 2023, the CMA made an interim order pursuant to Section 81 of the Act, preventing each of Microsoft and Activision and all members of their groups of internet-connected bodies corporate from acquiring in the other any interest conferring control within the meaning of Section 26 of the Act. On 19th May 2023, in accordance with paragraph 2(1)(a) of Schedule 10 to the Act, the CMA gave notice of the proposed order to remedy, mitigate, or prevent the SLC and any resulting adverse effect which it identified in the report. The notice and the proposed order were published on the CMA website. The CMA invited written representations on the proposed order from any interested person or persons with a deadline of 19th June 2023. In response to that notice, Microsoft made submissions to the CMA about developments since the publication of the report. These submissions stated that there had been a material change of circumstances since the report, or that there were otherwise special reasons for reaching a different decision on the remedies question. Microsoft provided its final and consolidated submission on these matters on 25th July 2023. A non-confidential version of Microsoft's 25th July 2023 submission was published on the CMA's website on July 31st, 2023. On the same date, the CMA published a notice inviting comments on Microsoft's submission with a deadline of 4th August 2023. The CMA received responses from interested parties in relation to Microsoft's submission, as well as in response to the initial consultation of the proposed order, which it has carefully considered. The inquiry group has decided under Section 41(3) of the Act that there has been no material change of circumstances since the preparation of the report, and that the CMA has no special reason for deciding differently. The inquiry group does not consider it otherwise necessary or appropriate to make modifications to the proposed order. Accordingly, the CMA now makes this order today to give effect to the remedy decision in the report. On making of this order, the reference is finally determined. The order. The CMA makes this order in performance of its duty under Section 41 of the Act and in exercise of its powers under Section 84, 1, 2, and 3, Section 86, 1, 3, and 4, Section 87 of the Act, and paragraphs 2, 12, 19, 21, and 22 of Schedule 8 to the Act for the purposes of remedying, mitigating, or preventing the SLC specified in the report, and any adverse effects which may be expected to result from the SLC specified in the report. Title: Commencement, Application and Interpretation. This order may be cited as the Microsoft and Activision Merger Inquiry Order 2023. This order comes into force on 22nd August 2023. This order ceases to have effect at the end of the prohibition period. This order applies to Microsoft and Activision and all members of their groups of interconnected bodies, corporate. The purpose of this order is to give effect to the report, and this order is to be construed consistently with the report and so as to give effect to its conclusions. In the event of conflict between this order and the report, this order prevails. Any words or expressions used in this order or the recitals of this order shall, unless otherwise defined, or in the context otherwise requires, have the same meaning as in the Act and the report. In the event of conflict between the order and the report, the order prevails, and in the event of conflict between the order and the Act prevails. References to any statute or statutory provision shall be construed as references to that statute or statutory provision as amended, reenacted, or modified, whether by statute or otherwise. References to recitals, paragraphs, and subparagraphs are references to the recitals, paragraphs, and subparagraphs of this order. In this order, any reference to a government department or non-departmental public body or organization or person includes a reference to its successor. The Interpretation Act 1978 applies to this order as it does to Acts of Parliament. In this order, Act means Enterprise Act 2002. Activision means Activision Blizzard Incorporated, a company incorporated under the state of Delaware and having its principal executive offices at 2701 Olympic Boulevard, Building B, Santa Monica, California. CMA means the Competition and Markets Authority. Group of interconnected bodies corporate means a group consisting of two or more bodies corporate, all of whom are interconnected with each other within the meaning of Section 1292 of the Act, where any two bodies corporate are interconnected if A. one of them is a body corporate of the other, of which the other is a subsidiary, or B. both of them are subsidiaries of one and the same body corporate. Interest means any interest conferring control within the meaning of Section 26 of the Act, which includes the ability, directly or indirectly, de jure or de facto, to control or materially influence the policy of a body corporate or the policy of any person in carrying on an enterprise, but without having a controlling interest in that body corporate or that enterprise. Microsoft means Microsoft Corporation, a company incorporated under the state of Washington with registered number 600413485 and having its registered office at 1 Microsoft Way, Redmond, Washington 980526399. Prohibition period means the period starting on 22nd August 2023 and ending on 22nd August 2033. Report means the report entitled Anticipated Acquisition by Microsoft of Activision Blizzard Incorporated Final Report published on 26th April 2023. Subsidiary unless otherwise stated, has the meaning given by Section 1159 of the Companies Act 2006. Unless the context requires otherwise, the singular shall include the plural and vice versa. Prohibition, except with the prior written consent of the CMA. For the duration of the prohibition period, Microsoft and all members of the group of interconnected bodies corporate to which it may belong must not acquire an interest in Activision or any of its subsidiaries, acquire an interest in an enterprise holding an interest in Activision or carrying on the business of Activision from time to time, or hold an option to acquire an interest referred to in subparagraphs 1 and 2 above, except with the prior written consent of the CMA. For the duration of the prohibition period, Activision and all members of the group of interconnected bodies corporate to which it may belong must not acquire an interest in Microsoft or any of its subsidiaries, acquire an interest in an enterprise holding an interest in Microsoft or carrying on the business of Microsoft from time to time, or hold an option to acquire an interest referred to in subparagraphs 1 and 2 above. Each of Microsoft and Activision shall procure that each of their subsidiaries complies with this order. Provision of information to the CMA. Any person to whom this order applies must promptly provide to the CMA such information as the CMA may reasonably require for the purposes of enabling the CMA to monitor the carrying out of this order or any provisions of this order, to review the effectiveness of the operation of this order or any provision of this order, or perform any of its functions under this order, or sections 84 and 92, 93 and 94 of the Act. Any person to whom this order applies and whom the CMA believes to have information which may be relevant to the monitoring or the review of the operation of any provisions of this order may be required by the CMA to attend and provide such information in person. Any person to whom this order applies who has any reason to suspect that this order is likely to be, has, or might have been breached must notify the CMA as soon as practicable and in any case within 3 calendar days from the day suspicion arose. Subject always to Part 9 of the Act, the CMA may publish any information or documents that it has received in connection with the monitoring or the review of this order or any provisions of this order, for the purpose of assisting the CMA in the discharge of its functions under or in connection with this order. Powers of direction. The CMA may give directions falling within this order to a person specified in the directions or a holder for the time being of an office so specified in any body or person, corporate or unincorporated. Directions fall within Article 19 if they are written directions to take such steps as may be described in the directions for the purposes of or being reasonably related to carrying out or ensuring compliance with this order, or to do or refrain from doing anything so described which the person might be required by this order to do or refrain from doing. The CMA may vary or revoke any directions so given. Severability. If any provision of this order is or becomes contrary to law or invalid for any reason, Microsoft and Activision must continue to observe the remaining provisions. Governing law. This order shall be governed and construed in all respects in accordance with English law. Any dispute arising concerning this order shall be subject to the jurisdiction of the courts of England and Wales. Any contractual obligations arising out of or in connection with this order shall be governed and construed in all respects in accordance with English law. And that's all. That's the order, my friends. That is the final order. Amazing that we've come to this point, and it's been so many months, but we finally have the final order. Now, let's read the final order explanatory note. So obviously Microsoft, CMA has blocked the deal, basically, in the UK. And this applies worldwide, obviously. But Microsoft, if they want to pursue the deal, if they really want to go ahead, they can potentially exit the UK. I don't know if that will happen. I don't know what's going to happen. But, oh, I just saw this. Microsoft Activision Blizzard X Cloud Streaming Rights Merger Inquiry. So this is a new inquiry. 22nd August 2023. Microsoft and Activision Blizzard have notified to the CMA an acquisition by which Microsoft will acquire Activision, excluding Activision's cloud streaming rights outside of the European Economic Area. The CMA is considering this as a separate merger investigation. This case page will be updated as appropriate for any developments impacting the final order. So we will read that later on. Let's first read this one. So, this is the explanatory note. The Microsoft and Activision Merger Inquiry Order 2023 explanatory note. This note is not part of the order. This is just them explaining to the public what's going on, basically, why they came to their decision and why they rejected Microsoft's submission. Introduction 1. On 15th September 2022, the Competition and Markets Authority, CMA, in exercise of its duty under Section 33(1) of the Enterprise Act 2002, the Act referred the anticipated acquisition by Microsoft Corporation, Microsoft, of Activision Blizzard Incorporate, Activision, the merger for further investigation and report by a group of CMA panel members. The CMA published anticipated acquisition of by Microsoft of Activision Blizzard Incorporated final report, the report on 26th April 2023. In the report, the CMA decided in accordance with Section 36 of the Act that the anticipated acquisition of Activision by Microsoft constitutes arrangements in progress or in contemplation which, if carried into effect, will result in the creation of a relevant merger situation. The creation of that situation may be expected to result in a substantial lessening of competition (SLC) in the supply of cloud gaming services in the UK due to vertical effects resulting from input foreclosure. C. The CMA should take action for the purpose of remedying, mitigating, or preventing the SLC or any adverse effect which has resulted from or may be expected to result from the SLC, and D. The prohibition of the merger would be the only effective and proportionate remedy to the SLC and any adverse effects which have resulted from or may be expected to result from the SLC. On the making of this order, the reference is finally determined. A review can be sought in relation to the order under Section 120 of the Act. Possible consequences of not complying with the order. Section 94 of the Act places a duty on any person to whom this order applies to comply with it. Any person who suffers loss or damage due to a breach of this duty may bring an action before the courts. Section 94 of the Act also provides that the CMA can seek to enforce the order by civil proceedings for an injunction or for any other appropriate relief or remedy. The CMA has power under the order to give directions, including directions to a person in their capacity as an office holder, for the purpose of carrying out or ensuring compliance with the order. Section 87 of the Act provides that if there is a failure to comply with the direction under the order, the CMA can seek to enforce the direction in court and may recover the costs or expenses of such enforcement. Review of this order. The CMA has a duty under Section 92 of the Act to monitor the operation of the order. This includes the duty to consider from time to time whether the order should be varied or revoked in the light of a change of circumstances. Status of this explanatory note. Nothing in this explanatory note is legally binding. In the event of a conflict between this explanatory note and any provision of the order shall prevail. Structure of the order. The order contains 25 articles. General provisions, Articles 1 to 11, which provide the title of the order, Article 1. The date it comes into force and ceases to have effect, Articles 2 and 3. The scope of the order, Articles 4 and 5. And interpretation, Articles 6 to 11, which also apply to terms used in this explanatory note. The prohibition, Articles 12 to 14, which provides Microsoft and Activision must not merge, as explained further below, within the prohibition period of 10 years from the date of this order. Compliance provisions, including provision of information to the CMA, Articles 15 to 18. The CMA's power to issue directions, Articles 19 to 21, and consequential provisions on severability and governing law, Articles 22 to 25. This explanatory note deals with each of the articles in the order. Articles 1 to 11, title, commencement, application and interpretation. The commencement date for the order is the date on which it is made, 22nd August 2023. The order ceases to have effect on 22nd August 2033. The order applies to Microsoft, Activision, and the group of interconnected bodies corporate to which each of them belong, and its purpose is to give effect to the report. Articles 12 to 14. Prohibition on merger. Article 12 provides that Microsoft may not acquire an interest in Activision or any entity holding an interest in Activision for 10 years, with an interest defined to mean the conferring of control within the meaning of Section 26 of the Act. This also applies to each of the entities within the Microsoft corporate group. As an exception to the general prohibition, the order provides that the CMA may grant its written consent for a transaction between Microsoft and Activision. This provision permitting the CMA's consent to be sought in relation to a particular proposed transaction is without prejudice to the right to request the CMA to vary or revoke the order on the basis that there has been a change of circumstances, as described above, and the CMA's standard merger control processes. Article 13 makes the same provision for Activision in respect of Microsoft. This also applies to each of the entities within the Activision corporate group. Article 14 makes provision that requires Microsoft and Activision to ensure that their subsidiaries comply with the terms of the order. Articles 15 to 18, provision of information to the CMA. Article 15 requires any person to whom the order applies to provide information so the CMA can monitor compliance with and the effectiveness of the order and fulfill its functions. Article 16 requires the production of records and provision of information in person to assist in the discharge of the CMA's functions in relation to the order. Article 17 requires the CMA to be informed immediately if a person to whom the order applies suspects that the order is likely to be, has, or might have been breached. Article 18 provides that the CMA may publish information received in connection with the order in compliance with Part 9 of the Act. Articles 19 to 21, powers of direction. Articles 19 to 21 provide that the CMA may give written directions so as to carry out or ensure compliance with the order. Article 22, severability. Article 22 provides that the remaining provisions of the order shall survive if some become invalid or contrary to law. Articles 23 to 25, governing law. Articles 23 to 25 provide that the order and contractual obligations connected with the order are governed by English law, and that any dispute connected with the order is to be heard in the courts of England and Wales. Okay, so that was the explanatory note. It wasn't what I thought it was. It was more like a legal explanation, and legally explaining each of the sections of the law. So I didn't really fully understand what it was about, like what it was explaining. But that might be useful to Microsoft in following the direction, I'm sure. But now we're going to read this. Microsoft, Activision Blizzard xCloud Streaming Rights Merger Inquiry. 22nd August 2023. Microsoft and Activision have notified to the CMA an acquisition by which Microsoft will acquire Activision, excluding Activision's cloud streaming rights outside of the European Economic Area. The CMA is considering this as a separate merger investigation. This case page will be updated as appropriate for any developments impacting the final order. So, let's have a look at this. A totally new merger inquiry now. Microsoft, Activision, Blizzard, xCloud streaming rights, meaning without the cloud bit, merger inquiry. The CMA is investigating the anticipated acquisition by Microsoft Corporation of Activision Blizzard Incorporated, excluding Activision Blizzard Incorporated's non-EEA cloud streaming rights. 22nd August 2023. Phase 1, 18th of October 2023. Deadline for Phase 1 decision. 22nd August 2023, launch of merger inquiry. 22nd August 2023 to 1st September. Invitation to comment. And I will definitely be commenting. I'll be emailing the CMA if I figure out if I feel that it's not sufficient and it's not going to be good enough to address the concerns. So 18th of October 2023, that's the deadline for the Phase 1 decision. I think it's funny that, they were saying that this will actually help things, speed things up by doing things this way rather than going through the tribunal, the CAT. You would have thought maybe going through the CAT at this point might have actually been the better route for Microsoft. Looking at it through Microsoft's point of view, they might have gotten a better result if they simply went through the CAT, but now they're having to go through a whole new merger inquiry. And this, rather than speeding things up, you might argue that it's worse for the consumer because it delays things even more. But as far as I'm concerned, the right decision has to be made, even if that takes time. So they need to be given time to make the correct decision and consider the changed deal, the restructured deal. So this is the restructured deal without the cloud gaming bit, which we did expect would eventually come, but I didn't realize it would be a whole new merger inquiry, which will take a lot more time potentially, because we know how long it took for the other inquiry. It took multiple years. I think it was in 2021 that the inquiry actually started, and then 2022 they gave the provisional findings. So this date is the current statutory deadline by which the decision will be announced. If any change occurs, the information is refreshed as soon as practicable. However, the CMA cannot guarantee that the decision will be announced on or before this current deadline, as the deadline of a given case may change during the merger assessment process due to different decisions. Phase 1. Launch of merger inquiry. 22nd August 2023. The CMA announced the launch of its merger inquiry by notice to the parties. Commencement notice PDF. Press release. Microsoft submits new deal for review after the CMA confirms original deal is blocked. Wow. So we're going to have a read through of these. Okay, let's first finish this one. I will open these in some new tabs. Invitation to comment. Closes on Friday 1st September. So I need to remember to comment on this because I really want to put forward my view to the CMA. Microsoft Corporation, Microsoft and Activision Blizzard Incorporated, Activision have notified to the Competition Markets Authority CMA an acquisition by which Microsoft will acquire Activision, excluding Activision's cloud streaming rights outside of the European Economic Area (EEA). As part of the proposed acquisition, Activision's global cloud streaming rights, excluding the EEA, for all current and future Activision PC and console games released during the next 15 years will be divested to Ubisoft Entertainment SA. Ubisoft. So this is for 15 years, not the previous 10 years that we had before with the cloud gaming deals. This is 15 years. It's a very long time. And Ubisoft, this is huge. Ubisoft is the company that is going to be getting the cloud streaming rights. This is absolutely huge. I'm kind of happy about this because I know Ubisoft is good when it comes to cloud gaming. There is the potential that they charge more, like they have the Ubisoft Plus, and that's really pricey. But I would see more. I doubt that it will happen for the free games like Overwatch 2, which I really want to come cloud gaming. I think that would still be free because they have these on Amazon Luna as well. So they're really good with all of the cloud gaming platforms. Even on Stadia, they were one of the pioneering developing companies that came to Stadia. And obviously they are on GeForce Now as well. So we will be reading through the new deal. So I'll be doing another video about this bit, since it's a new subject. Thank you for watching. So this is the new proposal. Okay, let me just finish reading this bit. The divestment will take place immediately before completion of Microsoft's acquisition of Activision. Ubisoft will also receive a non-exclusive license for Activision's EEA cloud gaming rights to enable it to stream and sub-licensed streaming of Activision games in that region. At the same time, Microsoft will receive a non-exclusive license from Ubisoft for cloud streaming rights to the extent necessary for Microsoft to fulfill its obligations.